We're here joined today with Lauren Drummond, who's a lawyer at Holding Redlich. Welcome, Lauren.
Thanks, Jodie.
So let's chat about flexibility. It's one that comes up a lot, and I think there's a lot of unknowns as to what you can and can't do. What are the rights in terms of when you're returning to work and requesting flexibility?
Yeah, so flexible work arrangements is actually a separate entitlement under the Fair Work Act. So it may be even after you've started a new job and you've been in the position for 12 months, or alternatively, you're just returning from a period of parental leave and you have a child that's under school age, that you can request flexible working arrangements. They might take different forms, from reducing the number of hours or working from home. The main thing is that in order to do so, you have to put your request in writing.
So if I put my request in writing for flexibility, what are the obligations of my employer to come back and let me know if it's approved or not?
Well, that's right. The employer has to let you know if the request is approved or if it's denied, and it has to do so in 21 days, and they have to do so in writing. And if the request is being denied, they actually have to explain to you the reasons that the request have been refused. And I think the really important thing to remember is that shouldn't be the end of the conversation. You should be able to reflect on those reasons and then go back with something further that will work for both parties.
Yeah, no, that's great advice. What about redundancy? I mean, I'm sure this is something that you see a lot from a legal perspective.
It's a common scenario, particularly in more of the smaller to medium-sized businesses, where they might not replace the role with a maternity leave contract. And during the parental leave period, they actually realise that perhaps they don't need that extra role, or that the role can be split amongst a number of other positions. So it does come up a lot. Again, there are obligations under the Fair Work Act that exist. First and foremost, the return to work guarantee. So if the role no longer exists and there's an available position of similar status and pay, for whom the person on parental leave is suitably qualified, then that position should be offered to them. Similarly, if you fall under the protections of the unfair dismissal regime, employers must take steps to redeploy you into another position. Otherwise, it will fall outside what's called a genuine redundancy, and that's a problem for employers in terms of defending an unfair dismissal application.
Yeah. Are there any, real examples that you can talk us through that you've seen from a redundancy perspective or flexible working?
What really happens in flexible working arrangement scenarios is a failure of employers to recognise the way the role can be shifted around and accommodated for an individual. I quite often have employers call me and their response is it's a full-time role. And
you hear that a lot.
I hear it quite a lot. So it's important to sort of break down the nuts and bolts of the role, because the grounds for refusing a flexible work arrangement can only be done so on reasonable business grounds. And that doesn't mean that it's a full-time role. It's things like, will it affect the efficiency, or will it be too costly? Will it have an adverse impact on customer service? They're the type of scenarios that are identified in the Fair Work Act.
Yeah, okay, interesting. So, discrimination, it's a big topic. What do women need to know?
Yeah, at a basic level, there's two types of discrimination, and one is not easily as recognisable. So there's direct discrimination. You're not offered a position because you're pregnant, or your position is altered to your prejudice because you've requested flexible working arrangements. The other type of discrimination is indirect discrimination, and that occurs in circumstances where an employer has implemented a policy or a requirement across the board that doesn't take into account the needs of persons with children at school age or who have carers responsibilities. For example, requiring a 9-to-5 working day for everyone in the office.
Yeah, okay. Would another example of an indirect discrimination be if I went for a role and I didn't tell them I was pregnant, but clearly I was 6 months pregnant, and then I wasn't offered the role?
Well, that's actually an example of direct discrimination. Okay. So if it's not immediately apparent that you are pregnant, it's certainly prohibited under the anti-discrimination legislation to ask an individual if they're pregnant during a job interview and then refuse to give it on those grounds. It's a bit trickier where they have had to make the assumption that you won't be available for the position after 3 months, and there might be there might be requirements that are inherent to the job as to why you were not offered that role, and that's actually an exception to discrimination.
Yeah, okay. So you obviously you mentioned that you work directly with employers. What are some of the trends, or I'm just interested, like, are you finding that more and more people are now, having to take things further from a legal perspective? You're seeing more discrimination, more cases rising?
Not necessarily. I think it is varied, but I do think there has been growth in individuals taking matters into their own hands. It's really quite a straightforward process if you're not getting anywhere within the workplace in the conversations with your employer, to make a complaint to the Fair Work Ombudsman or contact the Equal Opportunity Human Rights Commission in your state, and bring matters to a head by having a conciliation conference and working through the matter. I think it's important to remember that I think everyone wants a resolution that works for both parties, and it's not necessarily about compensation, but it's about getting people back into the workplace and finding ways to generate those conversations if they're not happening at the workplace level.
So at what point should you look to engage a lawyer?
It will depend on the circumstances of each particular case. For example, if you're in a fairly lucrative role and you have a bonus coming your way, but you fall pregnant and your employment is terminated before you're paid what's a very lucrative bonus, I would suggest you don't have time to wait to engage a lawyer and proceed through to court and the proper channels in order to recover that the money that you believe you've lost and it's flowed from a form of discrimination. But if it's a case of you're butting heads over flexible working arrangements and you think your employer's refusal has been discriminatory, you might take some channels, follow them through up to the conciliation point of either the Fair Work Commission or the Equal Opportunity and Human Rights Commission, and see if it can be resolved at that stage. And if it still can't be resolved, then you might consider engaging a lawyer. It just really varies in each case.
So Lauren, if you find yourself in a situation where you think you may have been, discriminated against, or there's a potential issue, what should you do?
In the first instance, I think go to your workplace policies. It may depend. If you're in a smaller workplace, that might not be practicable because the person who is the cause of the discrimination might be the decision maker, but in some instances there might be another decision maker. So consult your workplace policies and see if there's someone else you can talk to and raise your concerns about. If that's happened and it's been fruitless or that is not an option available to you, certainly encourage people to contact the Fair Work Ombudsman or the Anti-Discrimination Commission in their relevant state. They'll be able to provide them with some information as to how to push the matter forward.
And that's a hotline that people can call and have an over-the-phone chat about their particular situation?
That's right. And in some instances, the Ombudsman might take the matter on, but they won't do anything without your say-so, without your consent. Sometimes you might be looking for information. The other thing is if you really want to progress the matter further and the circumstances require a level of urgency, then it is open to you to file a complaint either with the Fair Work Ombudsman or probably more relevantly, the Anti-Discrimination Commission, whichever it is in your state, and they'll be able to progress the complaint for you, bring the parties together and try and find a resolution. I've found that the forms on those websites are quite user-friendly. You don't need to be a lawyer in order to fill them out. They take you through them step by step.
And what's the process like when you engage, say, Fair Work Ombudsman? I mean, other than the phone hotline, you mentioned the forms online, so that's obviously taking it to the next level and putting in an official complaint. Talk us through what the process is like.
Again, it will depend on the circumstances of each particular case. Sometimes it might just require the Ombudsman to give you some information, a template, something to help you generate the conversation with your employer. If something quite untoward has happened and you've been denied your entitlements, the Ombudsman might take the matter on. Similarly, in the Human Rights Commission, normally be appointed to a conciliator to take control of the matter and they'll try and get the parties together to have a discussion. It will then be up to, in Victoria, for example, if that is still unresolved, you then have a decision to make about whether you want to progress the matter to a court hearing.
Yeah. So it sounds like there's lots of help out there, and women shouldn't be afraid to reach out and seek help if they need it.
I think the starting point is really to have a strong grasp of what your workplace rights and entitlements are. Know the sources of those entitlements, whether they exist in the workplace policies or they're a basic entitlement under the under the Fair Work Act. And don't be afraid to have those conversations with your employer.
Yeah, great. Thank you.